Welcome once again to Fitz in Law School. I'm Fitz, and my God, it has been 10,000 years since last we spoke. I have been swamped this semester. I've also just been kind of lazy when it came to things that weren't absolutely necessary. And unfortunately, I know this might break some of your hearts, but this channel is not absolutely necessary. However, I thought that since we haven't talked in a while, we'd keep this video probably super general. And so by that, I mean, I want to talk about a couple of the things I've been working on this semester, also the classes I'm taking and kind of like my initial reactions and stuff to the class. Granted, every single thing that I'm going to say about the class is going to be my opinion. It's also going to be kind of based on how the class is taught. And so that has a lot to do with the class that you're in. It has a lot to do with your fellow classmates. It also has a lot to do with the professor and the book, just all those kinds of things. So like of course you guys get it. So thought I'd start out. This semester is going great. It's going really, really well. Really, really enjoying the subjects. Getting my, my second taste of, this is my second semester in law school ever. So just getting a real taste of what the, just different teaching styles and all that stuff. I mean, for some reason, I don't remember that much variation in the teaching styles of undergrad, or maybe I wasn't paying attention to that much, or I don't know. It was something like that, because I think that because it's so book intensive, it seems like this gives the professor a unique ability to shine in how they teach the book, because it's just, there's not that many variation of activities or something like that. It's not like undergrad, because undergrad is 40% book or 50% book, and then 50% like things you kind of actually did in class. Versus here, I mean, they can't avoid the fact that they're teaching for the test. Like the entire point is that you get a good grade at the end, which is the final, which is, basically the only thing that's graded. And so because of that, it seems like there's a lot more reliance that's placed not only on the book, but also because it's the test that matters, and the test is so, I don't want to say subjective, but it's so, it just kind of comes at the whim of the professor, that people just really pay attention to what the professor says and stuff. And like I definitely remember and I mentioned this in my last video, that I knew based on how some of the professors talked and how some of the professors reflected on the on the various cases that we talked about, that I kind of identified, oh, okay, like I know that this professor likes to talk about cases this way, or I know that they like to focus on the other thing. My contracts professor last semester, he really, really loved focusing on the story about the like surrounding case, like not necessarily like the what happened legally within the case, but just like a little cherry on top was the fact that he loved to talk about, just imagine the wider story surrounding this. And he always used to talk about, just imagine the Thanksgiving table, and how would they react sitting around the Thanksgiving table. And so I threw that into my final, and then I got like, another little thing, and he was like, oh yeah, you're right. And I was like, ha, I knew it. And so just, little things like that. And so that's why it's just very personality driven. And so I guess maybe that's why I'm paying attention to the professors a little bit more. But yeah, there you go. So let's just go through first the classes, then a couple of the other activities I'm doing. So number one, the first class that I started doing was property. And so property is a super interesting, I'm just going to say a couple things about each one of these classes. But property is a super interesting course, especially because you don't really realize how many things are connected to the area of property law. And so like one of the things I really, really loved about beginning property was the fact that we started, and we spent probably the first like 2 weeks or something like that talking about the origin of the idea of property. So that means the various places where ownership can come from. It can come from one person to another. It can come from discovery of that thing. It can come from buying it. It can come from conquering it. Just lots of interesting things, and lots of interesting like there was one interesting Supreme Court case that was talking about one of the descendants of Thomas Jefferson versus a landowner in like Ohio or something like that. But the Supreme Court was talking about the places in which both these people had titles to the same tract of land. One of them got it from the federal government. The other one got it from an Indian nation, many, many years before the guy got it from the federal government. And so the Supreme Court went through this really long thing, uh, explanation that essentially ended with, because the Indians didn't have title to it in the first place, therefore they're not entitled to sell it to someone. And it was a very, I mean, obviously it was racist and all that stuff, all the good stuff of back in the days, but it still just absolutely amazes me to see the process of law. I mean, there's just no process like it. There's no process where you have to justify what the hell you're saying. You can't just say things. You can't just make decisions. It's not like business. It's not like politics. It's not like I mean, the fact that it's public, the fact that this decision making process has to be public, and the fact that they write pages and pages and pages and pages of explanation saying exactly why they made this decision. I don't know. I still think it's very admirable. I still think it's a very amazing process. And, we don't have to do that. We don't have to do that as a society. We just decided to, and we're still doing it. Like, I don't know. I always think that's very cool. But the origin of property, and then the various ways that the idea of property has evolved over the years. I mean, obviously you kind of do that in torts, you kind of do that and all that stuff. But there was I mean, the days in which property used to be bought and sold was very dependent upon the nature of the property that was bought and being sold. So usually it had something to do with farming, and it had something to do with just like the land itself was the valuable thing. But nowadays, I mean, look at me. I don't own land. I own a sliver of a building on a piece of land in a bigger piece of land in a city. And so the nature of our interaction with these things has changed greatly. And so because of that, the law has, slowly at first, but it definitely has shifted over. I mean, it's like torts, in that strict liability is just adjusting to the way that we now deal with products. Because there's like one centralized producer of the products, and then it gets distributed all over the place. And so because of that, the best person who's in the position to correct a problem would be the producer, and so that's where strict liability comes from. It's the exact same thing with property law. And so, like the very first thing we ever learned in law school, during the orientation actually, was the implied warranty of habitability, and I believe that's universal in the entire country. I mean, I know it is in California, but it's essentially saying that when you go and enter an apartment building and you pay rent and stuff, there are things that come with that. Habitability, it has to have adequate lighting and heating and water and all those kinds of things. Say you're 1 month into your year-long lease, and there's some issues with the habitability of the rent or of the apartment. You can leave, even though you still have 11 months left on your contract. You can leave, and then you can say you have a legal case to say I don't have to pay the rest of that because they violated the implied warranty of habitability. And implied, it's not one single phrase. Each of these things have meaning, but implied is a term within contracts and within property, where if it's not specifically enumerated within the contract, if it doesn't say, we warrant to, or we represent to keep this apartment habitable and all that stuff. If it doesn't explicitly say that in the contract, it doesn't matter. It's implied within all property contracts, all rental property contracts. Anyway, it's a very interesting class, and you should be excited to listen or to learn about it. And we might do a video a little bit more about that. Next one is criminal law. So criminal law is super interesting, and my friend, she said, "Oh no, you're gonna like criminal law," and I said, "Why?" And then she sent a text back, and it was just the cover or the promotional poster of How to Get Away with Murder, which is pretty funny. But it's the origin for a lot of really good debates. Right now, we're going through the rape section of criminal law, and that's a pretty rough section, I have to tell you. I just wanted to get all that reading done one day, like earlier this week. And so I read like it was like 6 or 7 rape cases in a row, and it started to make me feel like weird and uneasy and stuff. Because I mean, again, you can see how someone could get jaded reading about this stuff, because I mean, this is just one story, especially in criminal law. This is one story after another of the most horrible things in civilization happening to people. And you know that it's thousands of people every single year. You know that it's tons of people, I mean, rape and child molestation. It's the worst stuff. And you read about it. And so, yeah, especially if you're a defense attorney, just having to deal with that every single day, that has got to be pretty rough on someone to deal with every single day. It's interesting to learn about the various ways that the United States, anyway, has tried to square rating different kinds of like things like murder and stuff. Criminal law seems to be a very element-driven area of the law. So that means that, like, if you have, if someone murdered someone and you have 3 of the check marks out of the 4, then the court will say, sorry. Like, it's obviously there's more nuance than that, but it's a very element-driven thing, and especially how we're being taught it right now. It is just list after list after list of the elements of each one of these things, first and second degree and manslaughter and all that stuff. So it's a very interesting thing. The third one is, so I had a choice this semester. I either had a choice of taking a constitutional law class or constitutional law, and so I'd have to take it this semester or next semester, my first semester of my 2L year, or I could take a statutory interpretation class. And so that it's exactly what it sounds like. The laws that are made by the legislature, those are called statutes. And then reading them is not that easy. And so because of that that means that there's actual classes on how to read these statutes. What the hell does this mean? And also, when you're a lawyer and you're arguing before a judge, how do you essentially inform them, okay, here's what this statute means? Looking at the legislative history, looking at the dictionary definition of the words, looking at what ways was the word that, like, a lot of times they're laws, they're statutes, they're all these things that you look at one word in the statute, one word, and you say, this is the word that's, the big yes or no kind of thing. Depending on the meaning of this particular word, that's whether or not my client is guilty or innocent. And so because of that, you look at all these different ways to read the statute. And the last one I was going to mention was someone, the way that the legislature used that word throughout all their other legislation or in that particular law. And then they say, okay, obviously they didn't all of a sudden switch over meanings. And so it has to mean the same thing all throughout the law. So there are 10 different statutory interpretation classes that I could have taken. So this semester, I'm taking IP statutory law. And so that's patents, that's copyrights, that's trademarks. And the reason I did that is because this summer, I'm probably going to be working for a tech company, especially dealing with privacy, but also, any tech company has to deal with trademark, IP, or patents at some point. And I felt like that class would actually make me a lot more interesting and valuable this summer for a tech company. And so again, it's all part of the plan. It was a little bit dry until I kind of got used to how I should be thinking about this course. Statutory interpretation in terms of a course is a very different way of thinking about the class compared to my regular classes, compared to, here's this area of law and here's the things that we're talking about and stuff. And so I had a little bit of an adjustment period about saying, how exactly am I supposed to be reading these cases? What exactly am I supposed to be looking for? And so it's interesting to see that each case has 2 things that you really have to pay attention to. The first one is, and the way that patents and all that stuff is read, is that it has its own sort of federal circuit that then goes straight to the Supreme Court. And so it goes from the patent office to the federal circuit, then to the Supreme Court. And that's for patents. But there are 2 things that you have to pay attention to in each case. The first thing is, what is that court deciding in terms of how do you interpret the statute, how do you interpret the Copyright Act or the Patent Act, or these kinds of things. And the second thing is that within the cases, what kind of canons, what kind of interpretive legislative canons does each court use in order to determine how to how to read that statute. And so it's kind of interesting that way. And the last course is, so last semester we had this thing called LRW. It's Legal Research and Writing. And so this semester we have LRW2. And LRW2 is slightly similar to LRW1, obviously. But what the twist on this is that we go and we get, we have one situation, a real case, but one situation where we spent half of the semester writing a appellate brief on that, and then the other half, we are practicing up to an oral advocacy argument. And so my oral argument is this coming week. And so I think our next video is actually going to be about oral advocacy and what it was like and all those kinds of things. But this is actually about a case that I believe has already been decided. I think it has already been decided. And so, but we don't know like how it's been decided yet. And so we like learn like right after we leave the courts, then we actually learn like how the real case actually turned out, which is kind of cool. But it's us versus another person in our class, and there's only 9 people in our class. And so because there's only 9 people in our class, that means that we had an odd number of people. So that means that one person had to do it twice. Who do you think volunteered to do it twice? So I have a pretty good feeling that this might result in me falling in love with oral advocacy, and maybe want to try it for moot court or something like that. But yeah, we'll see what happens. So that's that. And then on top of all my classes, I also have, and generally you're not really supposed to do this, and so I leaped at this because it was a great opportunity. So the city of San Francisco, the city attorney's office, had a position open for their data privacy task force. And so I leapt at the opportunity, and I went and I interviewed for it, and I got the job. And so I work about 16 hours a week during this semester, and it's not as time consuming as you would think. It is definitely one of those things where, you know, the second that I'm off the clock, then I'm off and I don't have to think about it anymore. The way that the charter has set up the city is that it's actually the city and county of San Francisco, and so that entire thing is controlled by the Board of Supervisors. And so that means they have a lot of services, they have a lot of things that they do for the people of San Francisco, and because of that, they also have a huge amount of data. And so this is a brand new field of law. This is something that we've never had to deal with before. And so this is various departments of the city going and contacting our department and saying, hey, I have this data, I want to do this with it, is that okay? And a lot of times we do the research and we say, well, you know, it is okay, or it's not okay, or it is okay, but you have to do these things, or it's not okay because of this, this, and this. However, if you do this, then maybe it's okay. And so, yeah, it's just been a lot of research. But yeah, so that's basically what my semester is looking like right now. I am a little more than, I think I only have a month left. Yeah, about a month left of my second semester. So next week, we are going to talk about oral advocacy, and I'm going to tell you about how it went, what I thought about the first compared to the second time, you know, all that stuff. So, yeah, until next time, guys. See ya.